Good afternoon, ladies and gentlemen. It's been a long 2.5 days. You've heard a lot of things, and I'm just going to try to go back over and hit the high points for you again. You've heard a lot of testimony, you've heard a lot of different stories, but some of it is basically the same. You've been introduced to Cynthia Barnett, you've been introduced to Earl Myrick. You know that they were in an on-again, off-again relationship for probably 1.5 years. She was living back and forth between Earl's house and Mama's house, and they both were using some drugs, particularly methamphetamine, on and off. You know, when people are doing that, usually they do fuss. It's usually on again, off again, because that's what happens when you use drugs. I'm sure they didn't always get along, and I'm sure they fought. I'm sure they argued. But in 2023, earlier in the year, something changed for Cynthia, for sure. She's living with her mom, Marlene, and So-So, and all of a sudden, this old friend, Preston Craney, shows up. She said in her interview he was an answer to prayer. So he comes back around, starts living at her mama's house, and she and he start having sexual relations. And that's based on her testimony and Preston Craney's testimony. So Cynthia said that during the day, if you go back and watch her interview, that, we just drove around, I rode around during the day doing my investigation. I don't know what she was talking about, but that's what she said. But Earl, during this time, was working for Bush Construction. He was a bucket truck operator there for Bush. And you met his foreman, Mr. Virgil Culpepper. So in the evening, or some evenings, Cynthia would go stay with Earl. Sometimes she'd stay at her mama's, sometimes she would stay with Earl. But on the evening of July the 13th of 2023, for whatever reason, Cynthia decided that she was done. She was done with Earl, and she decided that it was time to end it. Those are her words. Well, let me back up. Those were her words one of the times. One time she said she was going to get clothes and things. One time she said, I went over there to end it, and I told my family I was going to do it, and they knew I was. And then another time she said she was going over there to get pics of grandchildren and pictures of grandchildren or children. So I guess it depends on which time is the truth, but I submit to you the truth is she was going over there to end it. She was tired of Earl for whatever reason. Maybe she wanted to be with Preston. I don't know. But she was tired of Earl, and she decided that Earl had to die. So what does she do? She goes and gets Mama's gun out of her car. She knows where Mama keeps her gun. She gets that gun out of her car. She goes to Earl's house. Now, Earl, what's Earl doing? Earl's just gotten home from the Dollar General, pulled up on his motorcycle, minding his own business, not bothering anybody. Well, here comes Cynthia. And there again, Cynthia and Stephen, just Cynthia. It depends on which story you believe. But here comes Cynthia. And she pulls up there at Earl's house, and honestly, I can't tell you play-by-play what happened once she got there. And neither can Earl, because he's not here. But you can look at the evidence that you've seen from the witness stand, the evidence that's been submitted that you'll be able to take back with you in the jury room. And I want you to look at that. Once you look at those pictures, you'll see that there's a Dollar General bag right next to his motorcycle. Appears to have just been dropped right there. We know that he was at the Dollar General at 9:11 p.m. We know his only vehicle he drove was that motorcycle. It's right there in front. We know there's blood on the motorcycle. We know there's blood on the steps to the trailer. And we know in several spots in the yard, there's some blood. And if you'll go back and look at evidence markers 8, 9, and 10 on the pictures, you'll see where the blood is, what the general area of that is. Now, like I told you, I can't tell you exactly what happened. I'm not sure Earl ever made it off the motorcycle. Or maybe he was just getting off the motorcycle when she fired the first shot. Now, I know what you heard from her was, one of the times, that he was coming out of the house. Ladies and gentlemen, I submit to you that's just not true. If you look in those pictures, he got back from that Dollar General visit and he dropped that bag right there. If he had gone in the house, wouldn't you think he would take the Dollar General bag into the house and put it up before he comes back outside? No, he didn't do that. He got shot before he had an opportunity to go into his house. So Cynthia drives up, she's in her black car, and she tells you in her interview that I let the window down just this much. And if you go back and look at the interview, that's what she says. Now today, she said, no, it was way down. And I said, well, why did you say in your interview that it was just this much? And she said, I don't know. I don't know if they talked, she and Earl. I don't know if they exchanged words. I don't know if they were cursing at each other. I don't know what was happening out there. But what I do know is that she shot him, and I believe she shot him right after she drove up. I believe she shot Earl as he was getting off the motorcycle in the leg, and he turns and she shoots him again. Then he tries to go into the trailer. He's running for his life. He's running for his life. She talks about she's fighting for her life out there. There's no evidence of that. What there is evidence of is that he was running for his life. He's trying to get in that trailer to get away from her. There's blood all over the steps there. You heard testimony about that. It's in the pictures. Unfortunately, before he gets to the top of the step, he falls down and he dies right there at the foot of the steps where you saw his body lying on the pictures. Cynthia never said Earl was armed. Never said that. She said in her interview, he just got off this motorcycle. She says today he's coming out of the trailer. Well, why change the story? The reason is that if he's coming out of the trailer, that fits her story better, her self-defense story better. Much better than if he was just there on that motorcycle or just getting off the motorcycle. Now, Cynthia has told you so many stories, it's kind of hard to keep them straight. But in the interview, if you want to go back and watch it, I'd love for you to do that. She testified, or she said in her interview that first, she said, well, Preston and I went over to Earl's house earlier in the day. Earlier in the day. Well, she told you today, no, that really wasn't true. Well, then she said, I don't know what you're talking about. I didn't do anything to Earl. I don't know anything about it. I don't know what's going on. That's what she told law enforcement in the interview. Didn't have anything to do with it. Well, once she was prodded a little bit more, she said, I told you a story. I told you a story. I did it. I did it. I did it. And so there's where we are. She was arrested, charged with first-degree murder. Well, then, around August the 8th of this year, some year and a month after all this occurred, the story seems to go somewhat back, but not really, to the fact that Preston was there with me. Preston's there with me. We got to get Preston to come to court and say he was with me. Well, Preston had already been cleared by law enforcement. They had interviewed him, they had investigated that. Preston was not there that night. That's just the fact. He told you he wasn't, and law enforcement believed that he was not. There was no evidence that he was. But for some reason, it became important that Preston come in here and tell you that he was with her. Well, when we couldn't get Preston to do that, about a week and a half ago, we decided, Well, I've been lying the whole time still. I said it was just me, then I said I was gonna get Preston to say it was him, and actually it was my brother. And the whole time, I was just trying to keep my brother Stephen from getting in trouble. That's what I was trying to do. Well, help me figure this out. This is something that I've never been able to figure out through this whole thing. If you were just not trying to get Stephen in trouble, why bring Preston into it in the first place? If you just wanted to protect Stephen, why not just stick to the original story that you were there by yourself and you did it? Once again, the same reason as I said before. She needed somebody besides just herself to confirm her self-defense story, that he was coming after her. So Preston wouldn't do it, so we're left with Stephen. We're left with Stephen. Stephen will come say he was there with me and that Earl was trying to kill me. Now you can draw your own conclusions about Stephen's testimony. He didn't seem to remember much of anything. He said it was dark, but he also said it was early in the morning, but it might have been light, but I can't really remember. He didn't remember much of anything other than what he needed to say to help his sister not go to prison. That's what he pretty much remembered. So you'll have to be the judge of how much you believe about that. Now, if you'll go back through all the evidence, I think you'll see that most of the blood is concentrated in one area, with the exception of one piece that is back off, that is, I think it's marker number 4, and it's a piece of plastic. I think it's actually a whoopee cushion inside a piece of plastic is what it is. I don't know how it got there. There's been no evidence to that because nobody knows. But other than that, the blood is around the steps, around the motorcycle, and around just in front of the motorcycle. Ladies and gentlemen, Earl didn't have a weapon that night. Cynthia drives up, depending on which version you believe from her, either by herself or with Stephen. She drives over there, she cracks the window just a little bit, and then he supposedly charges after her. She's in fear of her life, she was fighting for her life. He doesn't have a weapon, her brother's in the car with her, and Stephen's a pretty good sized guy. He's in the car with her. They're in a car with the window cracked just a little bit, but there's no shattered glass when she shoots. And I believe, if you'll remember Stephen's testimony, he said, she was shooting like this. She was laid back on me, shooting like this. Well, if the window was just open that much, how is there not glass everywhere? Another inconsistency, ladies and gentlemen. I do want to point you to 2 different jury instructions that I want you to pay close attention to. These are jury S1A and S3. Those are the elements instructions. S1A is the element instruction for first-degree murder, and that's what we believe occurred here. And you can read it for yourself, but basically it says that on or about 13th day of July in 2023, in the 2nd Judicial District of Jones County, Mississippi, that Wilson Earl Myrick was a human being, and that Cynthia Barnett, without authority of law, did willfully kill Wilson Earl Myrick by shooting Wilson Earl Myrick with the deliberate design to effect the death of Wilson Earl Myrick, and not in necessary self-defense. And that's what we believe happened. We believe she armed herself that night with her mama's gun with the intention of going over there to kill Earl. But you do have another option. If you don't believe that, if you don't believe that what she did fits the definition of first-degree murder, then you have option number 2 in S3. And this is, if you find from the evidence, in this case, beyond a reasonable doubt, that on or about July 13th, 2023, in the 2nd Judicial District of Jones County, Mississippi, Cynthia Barnett, without authority of law, did kill Wilson Earl Myrick, a human being, by shooting Wilson Earl Myrick while in the commission of an act eminently dangerous to others and evincing a depraved heart, regardless of human life, although without any premeditated design to effect the death of Wilson Earl Myrick and not in necessary self-defense, then you shall find the defendant guilty of the lesser charge of murder, second degree. Those are the two options that the state would like you to consider, and you'll get to take these instructions back into the back with you as you deliberate. Like I said when I first started talking to you, ladies and gentlemen, you've heard a lot of stories. You've heard a lot of stories of abuse that came from Miss Barnett just this morning from the witness stand. But think back to her interview and go watch it again. What has she said now that she didn't say then? What did she say then that she's not saying now? What has changed? Why all the changing? Why all the changing? I've been doing this a long time, and one thing that I have figured out is that the truth never changes. A lie always changes, but the truth never changes. Mark Twain said one time, if you tell the truth, you don't have to remember anything. Makes sense, because it's the truth. It's what happened. But when you have 3, 4, 5 different stories about something that happened, it's kind of hard to know what the truth is, isn't it? Ladies and gentlemen, we believe that we have presented sufficient evidence to you for you to find Cynthia Barnett guilty of first-degree murder. We do not believe she was acting in self-defense. We don't believe there's any evidence whatsoever of that, other than her statement. We have seen no evidence whatsoever of all the abuse that she claims he inflicted on her. She never filed a police report about it. The one time she says she called the police, she said, I told another story and told them it wasn't happening, it didn't happen, and that everybody was fine. Earl's not perfect, and I'm not here to stand here and tell you that he was. None of us is. But he was a human being. He had siblings. He had people that loved him and cared about him. And despite the fact that Cynthia said she was one of them, I don't think you can just go over there and shoot this man right in his front yard when he's minding his own business and not even try to call and get him some help and claim that you love that person.
All right, for Ms. Barnett.
Yes, Your Honor. May it please the court.
Yes.
Ladies and gentlemen of the jury, do not let the state of Mississippi lead you to believe that they think Steve and her brother being there that night is a made-up story. Evidence of that is the fact that they went and arrested him last week for the same offense, because they know he was there. But in arresting him, they might have hope that that would cause issue at this trial. The story as to what happened at the scene, the story stated by Mrs. Martin, is mere speculation. It's not into evidence. It was not disclosed here today. Whether he was at the bike or after getting shot trying to go up the stairs, or why the blood was in certain spots, everything is speculation, which is what you are instructed not to base your conclusion and verdict on in this case. A lot's been said in this trial, a lot of stories, a lot of questions as to the legitimacy of how her interview was, what was stated a long time after the initial interview and what is the sequence of events that makes this make sense. There are rules of evidence in law pertaining to jury trials that prevent us from being able to talk about things outside of the trial. So I posit that to say, not everything can be explained to you. But as I stand here today, I am promising you that it is our belief and our argument that what she ultimately said today and what Stephen ultimately said yesterday is the truth as to what happened that night. Y'all have heard everything. I'm going to let each of you, or y'all are to judge the credibility of the testimony that's been provided. Now I want to talk about why we are actually here and what your duty, each of your duty is with regard to applying the facts that you've heard into evidence and the law in this case. Cynthia Barnett has been charged with first-degree murder, which means it's a specific intent crime. The state wants you to believe that she had the intent, and I quote Ms. Martin, for whatever reason, because they don't know. She, for whatever reason, decided to get a gun and go over to someone's house and who she had a relationship with, a toxic relationship at that, and just decide to kill him in cold blood. Proof beyond a reasonable doubt that took place. They say for whatever reason, like I said, because they haven't been able to provide you a reason in their case in chief. In fact, when I asked the lead investigator on the stand what Cynthia's intentions were when going over to Earl's house that night, he said, I don't know, I can't get in her head. Exactly, you don't know. Why Ms. Barnett didn't disclose absolutely every amount of abuse that she disclosed today in the first interview? One, it was soon after she had to pull the gun out and shoot somebody because it was kill or be killed. She lied, she's startled, she's not perfect. But to think that because she initially told a lie at the first instance, it doesn't mean that the rest of her story from there on out is absolutely, you can't consider it whatsoever. She's not perfect. But the difference between her giving us an explanation as to what happened and the state's case in chief is that she actually can say what happened because she was there. There's no witness from the state of Mississippi that can tell you what actually happened. You're going to have to speculate. That's what you have to do to conclude that she's guilty of murder beyond a reasonable doubt. I told you at the beginning of trial to keep this in mind. In my opening statement, I said keep this in mind. The law in Mississippi and the law that's to be applied today is that when someone asserts self-defense as a defense, which is what it is in this case, the state has the burden of not only proving murder beyond a reasonable doubt, but proving that she did not act in self-defense beyond a reasonable doubt. I recall when I asked Investigator Lewis, the lead investigator in this case, who was in the interview with her, I said, well, is it possible if what she said the second time after being startled and finally just letting it out, if that she was defending herself, do you believe that it's legitimate that she would be acting in self-defense? He agreed that it's possible. Is that proving beyond a reasonable doubt that she committed murder if the lead investigator is telling you that it's possible? No, it's not. The issue in this case, the main question in this case is not what did happen. We submitted to you at the very beginning before trial even began. She had a gun. She went over to Tater's. She ultimately used that gun. Okay, that is a homicide, which is something that I alluded to in voir dire. The difference between just merely a homicide and the crime of murder. Okay, every murder requires a killing, but not every killing is a murder. So we know what she did do, but the main question in this case is not the what, but the why. The why is what distinguishes her actions from a crime, which would be murder, or a justified act, which would be self-defense. We presented a case that she had a terrible relationship, she was abused, and that she wanted to get away, and that she had a plan to go over there, get her belongings, and leave. Her story was, she went over there, she asked her brother to go over there with her, and at that time, her life was threatened, like it had been threatened before, and she ultimately, upon Tater's actions in pursuing her, had a second to react. She did what she thought she needed to do to preserve her life. Now, that is something that you are to base what you think, how credible the story is. Sure, I'll posit that to you. But also remember that the law is, it's not her burden to prove that she acted in self-defense beyond a reasonable doubt. It's not her burden. That's not how our judicial system works in this country. They have to prove that she did not. And if they have not done that beyond a reasonable doubt, then the law requires you to find her not guilty. The only story they have is the one that was just made up out of Miss Martin's imagination as to what coulda, shoulda, woulda happened. What may have happened. But it wasn't presented in evidence. I asked you, like the court just recently instructed you, when you go back and deliberate, use your common sense. Is it more likely that, for whatever reason, the defendant decides to go over there and just shoot and kill the guy and back out? Is it more likely that that happened? Or is it more likely that she went over there to get away from him and get her things, and ultimately he threatened her life? What's more likely? Mr. Gray, my co-counsel, is about to speak to you after I'm finished, but I just leave you with this. When you go back there and deliberate, start thinking about what was presented into evidence in their case in chief. And I feel confident that applying your common sense, you will conclude, just as I have, that there was not evidence, other than speculation, that she had the requisite, the required intent to go over there and commit murder. And also that the evidence that was provided did not show that it is in fact beyond a reasonable doubt that she did not act in self-defense. It wasn't here today. Thank you.
Okay, please report. Counsel officer. Thank you, Mr. Sherman. Ladies and gentlemen of the jury, Cruz Gray, I'm going to follow up on some things Mr. Sherman just said, but I want to touch on just a couple of things that Ms. Martin said, and I want you to think about them, and when you go back to deliberate, I want you to do exactly what she told you to do. I want you to look at the evidence, look at the exhibits, recall what you heard from this witness stand today, and see if it matches up with some of these things Ms. Martin pointed out. Ms. Martin believes that Tater, Mr. Earl Myron, was running for his life. He was running for his life away from Miss Barnett. Why wasn't he shot in his back? Ms. Martin would have you believe that he was sitting on his motorcycle. She just pulled up and he's sitting on his motorcycle and didn't even have the chance to go inside. Why was his door open? Yeah, look at that. Look at the pictures of the trailer. Look at the top of the door frame and notice the door. The door is open. So if he just pulled into the yard, I guess, did he go to Dollar General and just leave his front door open? I don't think so. But I try to look at actual evidence when coming to conclusions, not my imagination. And finally, Miss Barnett? Oh, she didn't come forward. Oh, she didn't go into all the graphic, gory details of her abuse. Well, I guess she's the first abuse victim to never come forward then, isn't she? You don't believe that. What woman wants to sit on this stand and say the things that he did to her? What person wants to put themselves through that? She said she was embarrassed. I believe she was embarrassed. I wouldn't want to talk about those things. You know, it's funny. As attorneys, we're all about words. You know, most attorneys become attorneys because they're not good at math. That's me. But it's just so interesting how we can take a word or a phrase, and what my papa, wise man, I look back and remember him in his khaki coveralls, and he had all these little sayings and kind of southern things, and one of them was mountain into a molehill, or molehill into a mountain. I get it backwards, but you know what I'm talking about. And it's when you take something tiny, minuscule in size or importance, blow it up into this giant thing that it really isn't. And that's what Miss Martin has done with the words, end it. End it. Yes, Miss Barnett wanted to end it. She had been trying to end it. That didn't mean she wanted to kill him. That did not mean that she went over there with the intent to kill him. But see, there's this conflation, this mixing of timelines and the presence of fear within Miss Barnett's mind. There's a generalized fear that she felt of Tater. That was developed over a long period of time during their relationship, a relationship that she wanted to get out of but felt powerless to do so. There's this generalized fear that he may hurt her, he may hurt her family, that he was going to do something to her. Okay, that moment in time converged with another type of fear, an immediate fear, a fear that if she didn't kill him, he was going to kill her. Now, I would submit to you, the taking of the gun is correlated with the generalized fear. She took the gun to Tater's house because she was afraid of Tater. She was afraid of what he might do to her. She was afraid because of what he had done to her. She used the gun because of the specific fear she felt in the moment he came off that porch, rushing down to her car. You heard both Stephen and Cynthia say, the last thing Tater said to her was, "I'm going to kill you, you stupid bitch." The state's whole argument, their whole case, is premised on the mixing up of these two timelines, on the confusion, the conflation of generalized fear and specific fear. And it's not true. It requires you to speculate. It requires you to believe that Miss Barnett was in a state of mind when she got that gun that no evidence supports is true. It requires you to believe that she made the decision before she went to Tater's house, I'm going to kill him. It requires you to believe that at some point before she saw Tater, before she felt that immediate fear, I'm going to kill him. Ladies and gentlemen, it is not true. It's not supported by evidence. It's not supported by testimony from any witness. The only support for that theory is pure conjecture. It is a story. It is make-believe. It is a fiction. And it is not true. Miss Barnett said things that weren't true. What a luxury. What a luxury that some of us haven't gone through what she went through. The fear and the confusion that she must have felt having been in that relationship for the time that she was, and to have gone through what she just went through, I can't imagine it. And thank God. I don't want to have to imagine it. I hope that none of you have ever experienced anything like that and never have to. But, you know, when we go through things like that, we don't always think reasonably. We don't always do the right thing. And, oh, well, you know, the law says that I'm entitled to self-defense, so I should just go tell them. Nobody thinks like that in real life. This isn't Law and Order. This is real life. This is a woman who was abused. She was choked. She lived through hell for over a year with this man. And yes, she wanted to end it. She didn't want to kill him. There's no support to that theory. It is a theory. Ladies and gentlemen, you have to recognize the difference between speculation and fact. The facts are what Ms. Barnett told you from this witness stand. Everything else that you've heard, everything you've heard from the state, is just a theory of the case. Because it's their job to get a conviction. They want to prove their case. They want Ms. Barnett to be found guilty. So, you know, when you hear them say, everything you say can and will be used against you, they don't say, and we might help you out if you say something we like. They say, whatever you say can and will be used against you, not for you. So, ladies and gentlemen, as you go in the back and you review the evidence, I want you to take a look at some jury instructions. Ms. Martin pointed out some jury instructions, so I'm going to run through a few as well. Jury instruction D2A has to do with self-defense. Okay? If you believe that Ms. Barnett believed that Tater intended to kill her or do her some great bodily harm that was imminent and that he was capable of committing that harm, and she used self-defense to stop that harm, then you cannot find her guilty of murder. She legally used self-defense to defend herself, and that is an available defense to any person whose life is in peril at the hands of another. Whether or not he had a deadly weapon is really irrelevant if he was capable of doing her great bodily harm. You know, great weight has been placed on the fact that, oh, he didn't have a weapon, but you heard her say he was stronger than she was. He was stronger than she is. He could choke her. He had choked her. He had tied her up. That takes us to jury instruction D3. Or I'm sorry, jury instruction D5. If you believe from the evidence that the deceased was a stronger person than the defendant and was capable of inflicting great and serious bodily harm upon her with his hands, and that the defendant had reason to believe, and did believe, that she was then and there in danger of such harm at the hands of the deceased, and used a deadly weapon with which she fatally shot the deceased to protect herself from such harm, her actions were justified, and you cannot convict her of murder. Now, Cynthia was back and forth between homes. You heard a little bit about that. But she had a right to be at Tater's house. You heard there was a little bit of a conflation by the state because they said, well, she had this one story where she was going to get her clothes, and then she had this other story where she was all hung up on these pictures. But I would submit to you, if you go back and look at the interview, it all goes back to those pictures of her grandchildren. That was what was important to her. Clothes can be replaced, but, and we didn't really get into it, but there was this issue about these grandchildren that she couldn't see and the family hadn't seen. And she had some pictures of them at Tater's, and she wanted to go get them. And that's what she left to do that night, was to get those pictures. She had her things at Tater's house. She was living off and on with Tater. She had a right to be at Tater's house. If she was in a place that she had a right to be, and she was not the initial aggressor, then she had a duty. She had no duty to flee from Tater. And she does not lose her self-defense. She does not lose the right to self-defense because she just didn't back out of the driveway immediately when she saw him coming. In other words, if someone comes at you and you're in a place where you have a right to be, and you feel like they're about to harm you or inflict deadly force against you, you don't have to turn around and run from them. You can use deadly force to defend yourself. That's That's our law. And finally, jury instruction D3. We do not believe that this jury instruction applies, but for procedural purposes and representational purposes, we have to request certain jury instructions. And in D3, it talks about imperfect self-defense. We talked about whether or not Miss Barnett was reasonable in her belief that Taylor was going to hurt her, harm her, kill her, cause her great bodily harm. But even if she wasn't reasonable in that belief, she still could have defended herself without it amounting to murder upon the killing of Taylor. Even if it was not reasonable under the circumstances for her to believe that he was about to kill her, and obviously she did, but even if she didn't, she is only guilty of the lesser charge of manslaughter, not first-degree murder or second-degree murder. I know it's tedious to go through these jury instructions, and I'm reading from a sheet to you, and they're technical in their terms. But lawyers, like I said, are all about words. And I would submit to you today that the words "indent" do not mean what the state is encouraging you to believe that they mean. There are two moments, or two periods of time: generalized fear, specific fear. Remember that when you go back to the jury room and start your deliberations. There's a pinch point between those moments in time, no doubt. But the requisite intent for murder is on this side of that point. It's on this side of that moment in time where she had, yes, a fear of Taylor, but then at that moment, when he came toward her, she felt she had to use force to defend herself. And that's what she did. And for that reason, ladies and gentlemen, your verdict must be not guilty. Thank you.
Closing for the state of Mississippi.
Thank you, Your Honor. Defense counsel just told you that it was obvious that Ms. Barnett was telling the truth. Well, ladies and gentlemen, I submit to you the only thing that's obvious in this whole case is that she's a liar. That's the only thing that I've seen that's obvious. Why'd she go over there at all? I keep going back to that. She had a place to stay. She's staying at her mama's house. Her mama's got cameras. Her mama's got a gun. Preston's at mama's. Her brother's at mama's. She's got all the reason in the world not to go to a house where somebody who she's terrified of is. She said here today for the first time, he threatened to kill her the night before. Why would you go over to somebody's house that's threatened to kill you? Her story's changed multiple times. We've talked about that. The story that she's now telling is the only version of that story that perfectly fits her self-defense claim. And that's why she's now telling you that story, because we're at trial now. That's why now she's telling you that story. And defense counsel wants to make a big issue about, that I've just made all this up. This is all my imagination. Well, my witness that was there is not here. And that's always my disadvantage in a case, because when I have a murder case, my guy's dead. He's not here to testify. But they have you to believe that means, oh well, he's not here, so my gosh, you better just believe what she says, because it must be the truth. But which truth? The first one, the second one, the third one, the fourth one? Which one? Oh, the one that fits her self-defense narrative. That's the one she wants you to believe. Ladies and gentlemen, you all have common sense, and the judge has already told you, use your common sense. That's in the jury instructions. Another thing I wanted to clear up, Investigator Lewis, I think Mr. Sherman indicated that he even said it was possible self-defense. That was a little bit of a mischaracterization of what he said. Actually, it was a lot of a mischaracterization of what he said. What he said was, if you believe what Cynthia said, it could have been self-defense. He didn't say he believed it was self-defense. In fact, he said he did not believe it was self-defense. And I submit to you that he would have never arrested her if he had. She never told anybody about the
All right,
abuse.
stop this a second. Don't let anybody else come in and close an argument. You folks have a seat that's distracting. Sit down.
I'm sorry.
All right. You may continue.
Thank you. Cynthia never told anybody about Earl's abuse when he was here to defend himself. When he was here to say it never happened. She waited till he's dead and doesn't have a voice anymore. And now she makes all these unfounded allegations that he abused her. What evidence do we have? And I want you to think about this very carefully, that her life was being threatened at all that night. What evidence is there of that? She is sitting in her vehicle in his driveway by her own statement, and she wants you to believe her. The one thing that she's never changed is that she was in her car. She's driving her car. She's in her car. She says, I never got out of the car. She is in the safety of her car. He's out in the open with no way to defend himself. So what evidence have you heard that her life was being threatened? She has no marks on her. She has no choke marks on her. She has no scratches on her. She has no blood on her. She has no bruises on her. Nothing. She also said, I only had a second to react. And she didn't know what she was doing. She was just reacting. But she did know that she shot him in the chest, because she told you that up here. She did know that once she shot him the first time, he started to get back up. And I just shot him again. I just kept shooting him. Does that sound like self-defense? No. And then the defense wants to point out that, well, she didn't want to get up here and talk about these embarrassing things. Did she act embarrassed to y'all? I didn't think she acted embarrassed. In fact, I didn't think she showed any emotion at all. Now, they also brought up the point of, he had been in the house because the door was open. Obviously, he had been in the house because the door was open. Well, we don't know that she didn't go in the house after she killed him to get her pictures or belongings or whatever it is, depending on which story you believe, that she was going in there to get. We don't know that she didn't do that. And you know, another thing that just doesn't make any sense to me. If you're going to end a relationship with somebody, why not call them and end it? Why go over there in the dark, you say you're scared to death of him, you get a gun, you go over there under color of darkness. Sometime after 9/11, we know for sure at night, to get your things. What she could have done is she could have waited till a reasonable time, like maybe, let's see, maybe we could go when Tater's at work and he's not even there. And I'll get law enforcement to go with me, and they'll escort me to get my things. They do that all the time. They do it all the time. But we didn't do that. Ladies and gentlemen, I think it was a little funny to me that defense counsel got up here and talked about our case as being just full of confusion and based on confusion. In 25 years of doing this job, I have never been more confused by a defense theory than this one. Never. I've never been more confused by defendants telling of multiple different stories than this one. So I do take offense to the statement that our case for the state is based on confusion. I think your common sense tells you that the only confusion here is which story do we believe? Everything about what Ms. Barnett said is confusing. I'll go back to what I said when I got up here the first time, and I'm gonna close with this because I know y'all have heard more than you wanted to hear. But the bottom line is the truth never changes. It never changes. The truth's the truth. The truth was the truth that morning right after it happened. Not what you come in court when you're on trial and want to say to fit your narrative of your self-defense theory. The truth never changes. Thank you, ladies and gentlemen.